Hi everyone. In our last podcast, we looked at the decision of Indian Supreme Court in Hemlata Devi versus Uday Shri, which looked at the strong stance of Indian courts towards protection of consumer rights in arbitration. Now we will discuss the international position on arbitrability of consumer disputes. So let's begin with the recent UK decision on this issue. Ritika, can you please give us an overview of the judgment?
Sure, Alipak. So, in the recent case of Payward versus Maxim Chechen, the England and Wales High Court refused to enforce the foreign-seated arbitral award for being in violation of UK public policy. They held the arbitration agreement was unfair to the consumer and that the arbitrator failed to consider English consumer protection laws in their decision, even though the contract had a close connection to the UK.
I understand that the arbitration agreement said that any arbitration would be seated in San Francisco and any disputes would be governed by the US laws. So how did the court decide that the contract had a close connection to the UK?
So the court found that the present contract had a close connection to the UK for many reasons. First, the consumer involved was actually a British citizen who was living in the UK. The company who was operating the cryptocurrency exchange, so in this dispute we had a cryptocurrency exchange which was the business on the other side, that was actually UK based. The payments on this exchange for the services that they were giving were made in British sterling. All banking transactions were conducted through English bank accounts. So considering all of these things, they said that the contract had a close connection to the UK.
Interesting. Shweta, how does this approach differ from the position taken by the Indian Supreme Court in the Hemlata Devi case?
So the Indian Supreme Court had held that consumers have the option to approach consumer courts after the dispute arises, even if there was a pre-existing arbitration agreement in place. Unlike the Indian Supreme Court, the England and Wales High Court did not place much weight on the fact that the consumer did not elect to arbitrate the dispute subsequently. The court rather looked more at the fairness of the arbitration agreement itself. However, both courts agree on upholding the consumer protections provided by the respective domestic laws.
Right. How do other jurisdictions decide arbitrability of consumer disputes? Maybe Ritika, you can chip in on this.
Thanks, Aripak. So, we'd say India and UK have relatively taken a more protectionist stance as compared to jurisdictions like the US, Germany, or Austria. In US, Germany, and Austria, arbitration agreements for future or current disputes or future disputes are generally enforced as long as two conditions are met. First, that the consumer is aware of the arbitration agreement, and second, that the agreement in itself is not unconscionable. In fact, German and Austrian laws go a further step and add an additional layer. They require that consumers sign a separate arbitration agreement for any future dispute. What this ensures is that the consumer has actually explicitly consented to arbitrate the dispute, and it's not something they signed as like a standard form contract only so that they could get the goods or services in question.
I see. From a business perspective, there appears to be a need for careful drafting of arbitration clauses, considering the different jurisdictional requirements. Businesses catering to customers around the world must understand that the arbitration clauses may not always be enforceable.
Absolutely, and for consumers, it is essential to understand the implications of such agreements to avoid getting entangled in onerous arbitration clauses. As online shopping and cross-border transactions increase, even UK or Indian residents may be forced to participate in an arbitration in jurisdictions like the US if they're not careful about the agreements they're signing.
Thank you.